So, good morning everyone. My name is Abhay Singh and I welcome you all in today's video analysis of The Hindu. Today is 26th of August 2024 and we'll start with the first news headline for the day. So, the Foreign Minister of Brazil, Mr. Mauro Vieira, is currently visiting India, and India has presented has presented a kind of demand that basically around 600 Indian Indians have learned, they were got stuck in Brazil at the Sao Paulo airport. अब ये जो इंडियंस हैं वो वहाँ पे किस लिए फंस गए हैं? क्योंकि इनके पास जो अनडॉक्यूमेंटेड इमिग्रेंट्स इनको बोल रहा है ब्राजील that these Indians are undocumented immigrants. They don't have any document. They do not have sufficient document so that they can stay in Brazil. So अभी इनकी विजिट थी मौरो वियरा की, तो ये कंसर्न ये इशू रेज किया गया उनके सामने कि जो भी अनडॉक्यूमेंटेड इमिग्रेंट्स जो फंस गए हैं वहाँ पे उनको आप प्लीज़ जल्द से जल्द वापस हमारे कंट्री में भेजिए। और नेक्स्ट इंपॉर्टेंट थिंग जो मिस्टर मौरो वियरा के साथ डिस्कस की गई है दैट द नेक्स्ट G20 समिट इज गोइंग टू टेक प्लेस इन रियो डी जेनेरियो लेटर दिस ईयर। सो बेसिकली रियो डी जेनेरियो में जो G20 समिट होने वाला है उसका एजेंडा क्या होगा, ये चीज़ भी डिस्कस की है एक्सटर्नल अफेयर्स मिनिस्टर एस जयशंकर ने मौरो वियरा के साथ। ठीक है, तो अब आज की जो दूसरी इंपॉर्टेंट न्यूज़ है दैट इज रिलेटेड टू दी the attack by Israel on Hezbollah. So Israel launched a wave of air strikes across southern Lebanon early on Sunday in what it said was a preemptive strike to avert a large Hezbollah attack. So basically, Israel is continuously attacking southern Lebanon, and these attacks by Israel are basically conducted to or to avoid a large attack by Hezbollah. So now moving on to the next important issue for the next important news headline for the day. So this K Hema committee report, we are discussing this K Hema committee report for last 5 to 6 days. So there have been another development in this particular after this particular committee presented its report, and the development is that the Kerala state government, uh, after facing so much of criticism from various corners of the country, the Kerala state government has formed one special investigation team, SIT. SIT have been constituted by the Kerala government special investigation team. Now the main task of this particular SIT is to do preliminary inquiry or to conduct a preliminary inquiry into sexual harassment allegations. So basically, this special investigation team, which is constituted by the Kerala state government, has the main task of, basically has the main task of conducting a preliminary inquiry related to sexual harassment allegations made by the victims. Now we'll move to the third important news headline for the day. So this is the city edition. We don't have like Me Too movement in Bollywood puts LDF government on the back foot. So basically, this is again related to this K Hema committee report. After this particular report was presented by K Hema committee, the after this particular report was released by the Kerala state government, which was submitted in 2019, there have been wide scale outrage by the uh, various stakeholders from the different corner of the world. So now the uh, Kerala government is on the back foot because they are facing currently a strong opposition from the opposition. Now let's move on to this particular article. Now uh, this particular editorial is also related to K Hema committee report. So now you must have understood the importance of this K Hema committee report. We have been discussing this particular article for last 7 to 8 days. This particular report was presented or released by the Kerala state government on 19th of July, 19th of August 2024. And after this particular report was released, there have been a lot of criticism of Kerala state government. So we'll see what is the important recommendation and what is the philosophical insight from this particular article. Now, the Justice K. Hema Committee report, which was released by the Kerala government on August 19, 2024. So, the report was released on August 19, 2024. We have already discussed that the K. Hema Committee was constituted in 2017, which submitted its report in 2019, and the report was released in 2024. So, these are three developments. This is the chronology of the event which took place after the constitution of K. Hema Committee. It was a three-member committee which was headed by retired High Court Judge K. Hema. K. Hema was the retired Kerala High Court judge, and apart from K. Hema, there were two more members. One is actor Sharada, and another one is retired IAS officer KB Valsala. So this was a three-member committee constituted in 2017, which submitted its report in 2019, and the most important thing, the report was released after 5 years in 2024. And once this particular report was released and was in the public domain, there have been a lot of criticism. There have been a lot of criticism by the various corners of the society. So now let's focus on the next important aspect. So we have already discussed this. Now this particular report, this K. Hema committee report, broadly deals with two issues. Broadly deals with two categories of issues, and both categories are important. Both types of issues are important to understand the plight of the women in the Malayalam film industry. So the first broad category of the issues that have been flagged by the K. Hema committee are the issues related to sexual exploitation, sexual exploitation, harassment, and sexual favors. These sexual favors are basically demanded by the people. These sexual favors are basically demanded by those people who are at the higher authority, or they are in the dominant position. Now the second broad issue, the second category of issues that were being, that were raised by this particular committee, K. Hema committee, were discriminatory practices. Discriminatory practices female against the females. Discriminatory practices. So these are the two broad categories of issues that have been raised by this K. Hema committee. The first kind of issues were related to sexual exploitation, harassment, and assault, and the second kind of issues are basically related to discriminatory practices which are faced by the women workers. Now, and this particular report, this K. Hema committee report, has also raised one important issue, that is gender equality. Now, this is the main problem for every woman, not only in film industry. This gender inequality is a great problem for India, and why we are saying again and again this, that we should make uh, conditions which are more favorable for women. Why? Because until and unless we allow women to participate in the work, they will not, no, our country will not progress much, because in India there are only 32% women that are participating in actual work. So there have been a lot of gap. So we have to bridge this gap if you want to develop. So basically, this was a long-standing problem raised by the female workers who are working in the in this particular industry, that there have been a lot of पे गैप. अब पे गैप की जो प्रॉब्लम है, ये सिनेमा इंडस्ट्री की एक कॉमन प्रॉब्लम है, और सिर्फ इंडिया की नहीं. It is all across the world. There have been few exceptions, but all across the world this particular problem is common. Now let's focus on the next important aspect of this particular report, that is the culture of assault. Now, the concerns that are raised in Hema committee report are disturbing yet are not surprising. They are an extension of problems women face in a conservative patriarchal society such as ours. So now this we will discuss this particular philosophy in a bit detail. That what this K Hema committee has suggested, that now what the issues that are raised by this K Hema committee are not new issues. They are actually already, you know, they are in the society. They are already existing in the society, and the patriarchal mindset of our society and the conservative thinking of our society is the main problem of these kind of issues, because these are the people who are these people who are the part of this society. They will there is no hard and fast rule that if a person who is living in a society where patriarchy is very common, so if that particular person will go in the cinema industry or film industry, he will not follow those kind of practices in that particular industry. So basically, women in general in India face a lot of problems. A lot of they are burdened by basically a lot of stereotypes, and there have been a certain kind of unsaid norms that how they should behave, how they should talk, how they should, you know, not talk about their problems. So these are the things that have been long living in this society. So we have to particularly solve this particular problem. The next important issue that was raised by this K. Hema committee report was the normalization of objectification and gender stereotypes has a central role in perpetuating sexual assault against women. So basically, the report has basically suggested, no, no, the author of this particular article is suggesting that we need not to normalize the objectification and gender stereotypes because the issue of sexual assault, these problems, this normalization of objectification and gender stereotype precedes the sexual assault against women. So basically, this is the normalization of objectification and gender stereotypes are a part of a chain. And if we want to break this particular chain, then we have to stop the normalization of objectification and gender stereotypes. Now, as per the National Crime Records Bureau (NCRB), in 2022, there were 31,516 reported cases of rape in India, which means that a rape is taking place because an offense of rape is committed in every 16 minutes in India. And the problem of this harassment at the workplace is not new in India. For the first time, the Supreme Court of India has recognized this problem in 1997. When in Vishakha versus State of Rajasthan and others, the Supreme Court has specifically issued the guidelines related to the problems faced by the women at their workplaces. These particular guidelines were prescribed by the Supreme Court of India in 1997 in Vishakha and others versus State of Rajasthan. And these guidelines acted as a judicial legislation because there was no act in India at that particular time which specifically deals with the problem of women workers at their workplace. So this was something very important. The Supreme Court played very important role in 1997 after issuing guidelines to prevent workplace harassment in 1997. And after these guidelines were issued in 1997, it took exactly 16 years. It took exactly 16 years for the parliament to, enact a legislation on the same problem. In 2013, the Indian Parliament has enacted one law which is known as the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So Government of India has constituted this act in 2013, and this particular act came exactly after 16 years because Vishakha guidelines were issued in 1997 by the Supreme Court of India because there were no legislation or act in India to solve or to deal with the problem of sexual harassment at the workplaces. So this is just a bit of background. Now this particular legislation, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, have a very important provision, and the important provision is basically the Constitution of Internal Complaints Committee. Now the important provision is a Constitution of Internal Complaint Committee. So basically, this under this particular act, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, under this particular internal complaint committee, the aggrieved women can approach to the internal complaint committee and can file their grievances with this particular committee. Now, this is not, you don't have to remember this that the section 2 clause O of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 defines the term workplace. You just need to just have a glance at it. You don't have to like give efforts to remember this particular section. Now, let's understand the concept of this particular concept of internal complaint committee and what are the issues related to internal complaint committee. So we'll discuss that as well. Now let's start. The Justice Hema Committee report has, however, indicated that the Internal Complaints Committee is not suitable for women in the film industry. It is argued that there is a likelihood of the abuser or the employer influencing the ICC members. So this was the kind of apprehension which was made by Justice K. Hema Committee, that the Internal Complaints Committee, which was constituted under the Sexual Harassment of Women at Workplace in India Act 2013, the accused or the persons against whom the allegations have been made, they will try to influence the members of this internal complaints committee. That's why the Kehema committee was not in the favor of this adopting this particular model of internal complaints committee. Now, however, this is a problem that any internal complaint committee faces and is not unique to the industry. So basically, this is the common, this is very common, this is not limited to the film industry, that you work in any industry, you work in any profession, you work in any department, you work in any company. If there is an internal complaints committee, then the accused or the person against whom allegations have been made, he or she will try to influence the members of that particular committee. The reason being very simple, because that those person from an internal complaints committee are somehow related, or somehow the members from that particular profession or domain only. So that's why accused try to influence the members of the internal complaint committee, and that's why Kehema committee was not in the favor of adopting this particular model. Now, next important point is the registration of crimes. Many have questioned the lack of registration of crimes pursuant to the committee report. Now, basically, so many people are questioning, so many Indians are questioning actually, that why women not filing complaints, if they have given a statement in front of the Kehema committee, then why they are not filing complaint, formal complaint with the police department. Now the reason is very simple. Now the reason is very simple. We try so much, we try so hard that the identities of victims should not be revealed. But we all know that in India it is very difficult to hide the identity of victim, although there have been various kind of laws which clearly prohibits that the identity of female victims should not be released. But these guidelines, these rules are not followed strictly in India. Let's take a very fine example of the Kolkata rape and murder case. In that particular case, the unfortunate event took place on 9th of August 2024, and by 10th of August 2024, the images of victims and the name of victim was on the social media. So this is the main problem in India, that even if the victim will file an FIR or formal complaint with the police department, then her identity would be released, and her identity once the identity of the victim is released, that particular community, that particular industry will isolate her. They will not provide work to her. So this is the main problem why women are not filing FIR, because they do not have any assurance, they do not have any kind of assurance that once they file any complaint, their normal lifestyle will not be affected. So basically, women do not have that kind of assurance. That's why they do not file any formal or legal complaint. That's why they avoid to file a legal complaint. Now, masking the names of a survivors is done in recognition of the principle of survivor anonymity. Now, this is the principle of survivor anonymity, that we will not reveal the identity or the name of the survivor or the victim. And this is a well accepted principle in criminal jurisprudence on sexual assault, that this is the criminal jurisprudence on sexual assault, which basically prescribes that the identity of the survivor should not be released. It should be it should not be released, it should be very much protected. In Nipun Saxena versus Union of India. Now this case is very important. Nipun Saxena versus the Union of India. The judgment was delivered by the Supreme Court in 2018, and in this particular judgment, Supreme Court explained the importance of why the person who are revealing the identity of the victim and the survivors should be penalized. The Supreme Court explained the importance of penalization of the disclosure of the name and the identity of the survivors' sexual offences as mandated in Section 228A of the Indian Penal Code, which is now reiterated in Section 72 and 73 of the Bharatiya Nyaya Sanhita. So earlier it was Section 228A of Indian Penal Code, which basically penalized, which provides punishment for the people or the authorities who are revealing the identity of the survivor. Now the Indian Penal Code has been altogether replaced with Bharatiya Nyaya Sanhita. So now instead of Section 228A, this is Section 72 and 73 of Bharatiya Nyaya Sanhita, which deals with this particular specific issue, that if a person will release or reveal the identity of the victim, then he or she will be prosecuted accordingly. Now The judgment of in the judgment, the court said that the object of the provision is to protect survivors from hostile discrimination and future harassment. Now we are living in a country where people are not much educated, and we have to accept this fact that in India the society is very primitive, the conservative thinking. So all these kind of problems will be faced by the victim in itself, because that victim will live in the society. That victim is the part of the society, and once her identity is revealed, then the whole society will treat her with the utmost hostile with utmost hostility. So to prevent these kind of things, to provide that particular survivor and victim a fair chance of living with their dignity, this particular provision was made that the identity of the female survivor should not be released under section 228A of IPC. Now IPC has been replaced with Bharatiya Nyaya Sanhita, so section 72 and 73 of Bharatiya Nyaya Sanhita deals with the same issue. Now, also one important thing that we have to keep in mind, that the Supreme Court of India in K. Puttaswamy case, has declared that the privacy is a fundamental right of a person under Article 21. So now, if the privacy is a fundamental right, and if we are revealing the identity of the victim, then we are actually breaching that, or we are violating that particular fundamental right of the victim. Now the various statements had been given by the victim in front of the committee, and they were in the kind of belief they were in the belief that their identity or their anonymity will be maintained. But again, the identity of several victims have been released. The right to decide whether to pursue a criminal case does lie with the victim. Now, at the end of the day, it is the victim who will decide that whether she or he wants to file a complaint or not. Because at the end of the day, the crime might be against the society, but the whole society is not suffering because of that particular crime. Only that particular person is directly affected जो उस crime को face करता है. Just take one fine example. In Kolkata rape and murder case, the direct loss was of the family. We all are protesting against that particular event, unfortunate event, but the direct loss was to the family. So at the end of the day, the decision to pursue a criminal proceeding lies with the victim only. And if it is true that in our criminal justice system, the state initiates prosecution against the accused, arguing that and conducting the case on behalf of the victim. However, and if the state investigates the crime, it becomes quite difficult to prove a crime without the cooperation of the victim. So now in India, now not in India, in our judicial system, in our justice system, it is believed that when a crime is committed, that particular crime is not against a person, but it is a crime against the society. So impliedly, state becomes a party in these kind of cases, in criminal cases, and on the behalf of the victim, it is the state who will investigate the crime, will collect the evidences, will present it in the court, and will prosecute the accused. Now, without the cooperation of the victim, suppose take this example: there is a woman named X. There have been a case of sexual assault. There was a sexual assault on her. Now, if she does not want to file a complaint for that particular sexual assault, state will take the course. State will file an FIR, and on the behalf of the victim, state will start the investigation. But at the end of the day, it is the victim. If victim is not cooperating, then the state cannot do anything. So we have to provide more surety and more guarantee to the victim, that if you will file a complaint, if you will give the statement to the police or any other authority, then your life and your career is safe. Because in India, the kind of problems that women are facing are very adverse. Some problems are even not acknowledged by the many. So that's why this kind of assurance is very important, so that victims can participate in this particular process. Victims can participate in the process of investigation. Victims can give this statement in the court of law. Because of the fact they do not have any kind of surety, they do not their identity is revealed, uh, their privacy is interfered. That's why they do not cooperate with the investigation. This is the only reason, that the kind of problem they face from the society. And also अ, ऐसा ज़रूरी नहीं है कि वो स्टेटमेंट देने के बाद उनको जस्टिस मिल ही जाएगा, और उनके दिमाग में ये भी डर रहता है कि अगर हमने कोई स्टेटमेंट दे दिया तो हमारे हाथ से हमारा काम चला जाएगा। तो जब तक उनको ये श्योरिटी हम नहीं देंगे कि आप अगर कंप्लेंट फाइल करेंगे तो आपकी लाइफस्टाइल पे और आपके कामकाज पे कोई फर्क नहीं पड़ेगा, तब तक वुमेन कभी कंप्लेंट फाइल नहीं करने आएंगे। क्योंकि हमारी सोसाइटी में वुमेन का काम करना ही एक बहुत बड़ा चीज हो जाता है, एक बहुत बड़ा अचीवमेंट हो जाता है। ठीक है कि हाँ, हम तो अपने घर में वुमेन को काम करने के लिए भेजते हैं। सो दिस इन इंडिया दिस इज ट्रीटेड एज अ काइंड ऑफ अचीवमेंट। तो इस वजह से भी वो लोग कंप्लेन करने से थोड़ा सा कतराते हैं। तो ये सारी चीजें जब तक हम उन्हें अश्योरेंस नहीं देंगे कि योर लाइफ एंड नॉट योर लाइफ एग्जैक्टली, योर करियर इज सेफ, तब तक वो लोग कंप्लेन नहीं फाइल करेंगे। नाउ with this we have completed this particular article. The this particular article in while concluding this particular article, the events of 2017 were discussed when this hashtag Me Too movement was started, and then we have discussed this KHEMA committee report. What are the structural reforms that have been suggested by this KHEMA committee, and how we can make environment more more vigilant and more coercive for the female employees who are working in the Malayalam film industry. So this is one important thing that we have covered today. Now let's move on to the next important article. And next important article is related to the new age gateway devices. New age gateway devices, the latest health threat. So basically, so what are these new age gateway devices? So these are basically vaping pens, e-cigarettes, which have been discussed, and what are the impacts of using these e-cigarettes and vaping pens. Because when these particular devices were introduced, that they are an alternative, they are an alternative, uh, they are an alternative to smoking. They are an alternative to smoking, and these alternatives will provide and not provide, but they will make easier to quit tobacco. So the premises on which these devices were introduced, that these devices will provide a healthier alternative to quit the smoking. Now this particular hypothesis on, or the particular presumption on which these devices were introduced, those presumptions are being challenged in itself. Now those presumptions that these devices are the healthier alternative, now this particular notion is questioned, that the healthier alternative, how these new age gateway devices are healthier alternative, whether these new age gateway devices are healthier or not. So these are the things that have been discussed in this particular article. Now let's start this particular article. This had led to a surge in youth vaping, creating a new pandemic. So basically, these devices are introduced with the very basic presumption that they are a healthier alternative. So इससे क्या हुआ कि जो बहुत से लोग थे जो स्मोकिंग करना चाहते थे, जो टोबैको कंज्यूम करना चाहते थे, दे थॉट दैट इट इज बेटर to consume vape and e-cigarette, to use to smoke e-cigarettes and vape. Now it has been scientifically proven that e-cigarettes and vaping pens cause equal damage. There's one example. E-cigarettes were the most commonly used tobacco product among middle and high school students in United States, with 2.1 million, 7.7% students using e-cigarettes, including 550,000 middle school students. So in United States of America, the culture of using these vaping pens and e-cigarettes is very high. In United States of America, 2.1 million students are using e-cigarettes. Children have been lured into trying and becoming addicted to e-cigarettes and vaping devices through a targeted marketing of flavors. Now the marketing strategy which was used by these vaping companies was actually great. They have basically introduced different kind of flavors in these vaping pens: strawberry, cotton candy, pop rocks, and lemonade. These are just few examples of the flavors which have been introduced by these companies, and the tactic worked for these companies, because once the flavors were introduced, everybody was kind of, if you ask them what are you vaping, then they will say, oh no, I'm vaping this cotton candy flavor, vaping this pop rock flavor, I'm vaping this green apple flavor. So basically what's happening is that the companies are playing with the mindset of the children, because the crowd or the age group which is consuming these products is basically does not have that sufficient understanding that they can understand, or they may understand the consequences of vaping and other things. So the marketing strategy was great we have to understand that how this vaping and consuming e-cigarettes is affecting the life of the children. First is that the children are is increasingly susceptible to new age devices from an early age. What was once an adolescent concern for engaging in distracting activities and developing addictive tendencies has shifted with even those under 10 years of age now. Signs of vulnerability. The age group most at risk remains between the 10 and 20 years, a demographic that manufacturers allegedly exploit through appealing advertising and enticing vaping flavors. So now how the mindset or the psychology of these consumers who are between the age of 10 to 20 is affected by, adopting very lucrative marketing strategies and enticing vaping flavors. The enticing vaping flavors that we have already discussed. The second aspect is that the impact of such habits will have on the physical and mental well-being of the children. So when a body is young, a body can, tolerate a lot of things. But when a body starts getting older, then a body, the strength of body gets low. So once you start consuming these kind of devices, once you start consuming tobacco from very early age, so your body will end of the day your body will not show much of the symptoms that you are consuming this particular thing, but after a certain age your body will show signs that yes, you have consumed at some point of life in your life, you have consumed certain kind of things. So basically the kind of effect that these vaping devices are leaving on the physical and mental well-being of the children is very great. Now, the Australian Institute of Family Studies, we have discussed another important example, another important statistics, and this is related to Australian Institute of Family Studies, that the evidence indicates that the vaping has negative effect on people who use e-cigarettes. So now, this is a very shocking revelation that was made by the Australian Institute of Family Studies, that the person who was actually use vaping or vaping pens, they and the person who are using e-cigarette, if a person is using vaping pens, then he will face negative side effects if he is consuming e-cigarettes. Such new age gateway devices are associated with mental health challenges such as depressive symptoms, anxiety, perceived stress, and suicide-related behavior among other adolescents. So basically, there are various kind of side effects that the children will face: anxiety, perceived stress. So stress, anxiety, BP, depression, suicide-related behaviors. So these are the side effects of consuming these kind of for these kinds of products. The more adolescent e-cigarette users reported using their first tobacco product within 5 minutes of waking when compared to users of cigarettes and other tobacco product combined. Now, this is also important fact that we have to understand that the more adolescent e-cigarette users reported using their first tobacco product within 5 minutes of waking. So, जितने भी यंग एज ग्रुप में लोग हैं वो उठने के विद इन 5 मिनट्स जो ई सिगरेट्स कंज्यूम कर रहे हैं वो उठने के 5 मिनट्स के अंदर कोई टोबैको का प्रोडक्ट कंज्यूम करते हैं. So this data is also, exactly telling how these e-cigarettes and vaping devices are affecting the psychology and the lifestyle of the consumers. The study further said that e-cigarettes are highly engineered drug delivery devices designed to create and sustain addiction. So this is useless. That this was the healthier alternative to smoking. There is nothing like that. That vaping and e-cigarettes are the healthier alternative of the smoking. This is not like that. And in that particular study, it has been also said that just like the slow poison, companies are using methods which will, slowly addict the person towards that particular flavors and towards those particular devices. तो कुछ ऐसे डिवाइस स्लो पॉइजन में जैसे आदमी को आप देते रहिए तो उसको बहुत लेट में डेथ होती है, वैसे ही जो टेक्नोलॉजी यूज़ की जा रही है इन वेपिंग डिवाइसेस में बेंजोनिक एसिड वगैरह का यूज़ किया जा रहा है, इससे क्या होगा कि जो आदमी को लत लगेगी दैट विल बी एट वेरी स्लो पेस, उसको पता भी नहीं चलेगा कि दैट ही हैज़ बिकम एडिक्टेड और उसको फिर उसके साइड इफेक्ट्स देखने पड़ेंगे. फिर देन वी आर बेसिकली डिस्कसिंग अबाउट दिस जस्टिस वर्मा कमेटी अभी जस्टिस वर्मा कमेटी को अभी डिस्कस करने का पॉइंट क्या है? अभी डिस्कस जस्टिस वर्मा कमेटी को डिस्कस करने का पॉइंट सिर्फ इतना है कि जो 2012 में निर्भया केस हुआ था, निर्भया केस के बाद ये जस्टिस वर्मा कमेटी कॉन्स्टिट्यूट की गई थी। और उस जस्टिस वर्मा कमेटी 2012 में कॉन्स्टिट्यूट की गई थी दिसंबर में, और जनवरी 23 2013 को इसने उन्होंने अपनी रिपोर्ट प्रेजेंट की थी। एंड दिस जस्टिस वर्मा कमेटी वाज रिलेटेड टू basically related to the offense of rape, that what kind of punishment should be given to the person who are involved in the heinous crimes against the woman. So this particular committee was constituted in 2012. Now the key amendments that were brought after the recommendations of the K. Verma committee were the death penalty for rape that led to death of the victim on or reduced her to a persistent vegetative state. So basically, death penalty for in those cases uh, where death of the victim took place, and also the after the rape the victim was in a vegetative state, then Justice Verma has suggested that death penalty should be provided for these kind of offenses. And anyone found guilty of rape more than once, if somebody is committing rape more than once, then he should also be then also death sentence should be provided. In 2018, further changes introduced death as the maximum punishment for every participant in a gang rape when the victim is less than 12-year-old. So in 2018, another change was made that it was made compulsory that if the victim is below the age of 12 years, if the victim is below the age of 12 and a gang rape has been committed on her, then if a gang rape has been committed on her, then what will happen? The death sentence will be provided. And if the victim is between 12 to 16, then the provision of lifelong imprisonment under Section 376 DA of the Indian Penal Code. Now, so these were the major suggestions of the Justice Verma Committee, and the major reason why we are discussing this particular report. The reason is very simple and very clear, that because of the Kolkata rape and murder case, we are discussing this particular news item. So let's move on to the next important part of today's newspaper. So basically, this is related to the classical languages center ask for the classical language centers ask for autonomy. So in India, there are total six classical languages. In India, there are total six classical languages. And what are these classical languages? So basically, these are classical languages. So let's understand few more important things related to classical languages. That in India, in 2004, Government of India has created one category of languages, those that are known as classical languages. And after creating this category in 2004, subsequently Government of India in 2006 laid down the criterias for declaring any language as classical language. So criterias are basically the language should be minimum 1500 to 2000 years old. अपना खुद का लिटरेचर वैल्यूएबल लिटरेचर होना चाहिए. So these are the various criterias on the basis of which a specific language is declared as the classical language. Now, at the end of the day, it is the responsibility of linguistic expert committee to suggest recommendations regarding the classical language status. Now, this linguistic expert committee is headed by the president of Sahitya Academy. So basically, this is the background of classical languages. The category was created in 2004. The conditions were laid down in 2006. This is the at the end of the day, it is the linguistic expert committee which recommends the criteria for the declaring any language as the classical language. And this linguistic expert committee is headed by the president of Sahitya Academy. So this is just the background of these classical languages. In India, there are total six classical languages. India में total six classical languages है. कौन-कौन सी हैं? तमिल, तेलुगु, कन्नड़ा, मलयालम, Sanskrit, and Odia. So these are six classical languages in India. Odia was, given the language of classical status in 2014. So these are the six classical languages in India, and what are the benefits of having uh, on or getting the status of this classical language? So the benefit is very simple, that once a language gets the classical language status, then the government of India or this government will provide the financial assistance to establish a center of excellence for that specific language, to establish a center of excellence for that specific language. This is the first important benefit that the people will get. That once take this example, that there is one X language, Mara, there was this X language. Now the अब एक्स लैंग्वेज को अगर स्टेटस मिल गया क्लासिकल लैंग्वेज का, तो गवर्नमेंट क्या करेगी, एक सेंटर ऑफ एक्सीलेंस स्टैब्लिश करेगी जहां पे सिर्फ एक्स लैंग्वेज को पढ़ाया जाएगा. सो ये पहला एडवांटेज है. दूसरा एडवांटेज क्या है कि एक अवार्ड ऑफ आप दो इंटरनेशनल अवार्ड्स क्रिएट कर सकते हैं. और ये इंटरनेशनल अवार्ड्स किसके लिए आप क्रिएट करेंगे? स्कॉलर्स ऑफ फेमिनिस्ट, मतलब उस पर्टिकुलर लैंग्वेज के जो इम्पोर्टेंट या इंटेलिजेंट स्कॉलर्स हैं, एमिनेंट स्कॉलर्स हैं, उनको आप ये अवार्ड देंगे, अवार्ड ऑफ एक्सीलेंस. दो अवार्ड देने पड़ेंगे. और इसको तो हम ऑलरेडी कवर कर चुके हैं कि एक सेंटर ऑफ एक्सीलेंस क्रिएट करना होगा. सो बेसिकली ये सारा था क्लासिकल लैंग्वेज का बैकग्राउंड. अभी हम किस कॉन्टेक्स्ट में इसको देख रहे हैं? अभी बेसिकली हम इस कॉन्टेक्स्ट में देख रहे हैं कि जो ये सेंटर स्टैब्लिश करती है गवर्नमेंट, जो भी मैंने अभी आपको बताया कि गवर्नमेंट कुछ फंड्स देती है, फिर वो एक सेंटर स्टैब्लिश करती है जहाँ पे बेसिकली उसी स्पेसिफिकली उसी लैंग्वेज को पढ़ाया जाता है. सो ये जितने भी सेंटर्स इंडिया में हैं, ये लोग बेसिकली डिमांड कर रहे हैं कि इनको बेसिकली ऑटोनॉमस बना दिया जाए, दैट दे शुड हैव द ऑटोनॉमी ऑफ डिसाइडिंग वेरियस थिंग्स. नाउ India has six classical languages. We have while four of the centers for classical. Now, this is important that in India there are total six classical languages, and and out of these six classical languages, four educational or the center of excellence. Four center of excellence are controlled by Central Institute of Indian Languages (CIIL). Mysuru, the center for Tamil, is autonomous. Now, अभी तमिल लैंग्वेज का जो सेंटर है, इट इज वर्किंग एज ऑटोनॉमस. सो बेसिकली इंडिया में जो टोटल 6 सेंटर हैं, इसमें से 4 हैं CIIL के अंडर और 2 हैं ऑटोनॉमस. ठीक है. एंड द मोस्ट शॉकिंग revelation is that that was answered by the government in 2020 Lok Sabha, that out of the 643 out of the 643.84 crore rupees that have been spent on the promotion of Sanskrit. So government has spent 643.84 crores on the promotion of Sanskrit, but government has spent only 29 crores over other 5 languages. So here the average is 6 crore per language. So what this basically this article this is quite a staggering fact, that on Sanskrit government has spent 643.84 crore, and on other languages government is spending roughly around 5 crore 80 lakhs rupees on each language. So that's why these that they are demanding that they should be declared as the autonomous. And also the bodies which are not autonomous, if they want to conduct any function, they need certain kind of financial assistance, then they have to take the prior approval from the CIIL. Until and unless the CIIL gets this final approval, those financial sanctions were made by the CIIL, will not be able to organize these functions. And also sometimes it happened that they have to organize the function which are not autonomous, the centers which are not autonomous, that they have to organize some kind of function and they are compensated at the later stage. So बस आप इतना याद रखिएगा कि 6 लैंग्वेजेस हैं क्लासिकल लैंग्वेजेस, और उसमें से अभी 4 लैंग्वेजेस ऐसी हैं जो CIIL के अंडर 4 सेंटर्स हैं जो ऑपरेट कर रहे हैं और 2 सेंटर्स ऑटोनॉमस हैं। सो बेसिकली जितनी भी लैंग्वेजेस हैं वो सब लोग ये डिमांड कर रहे हैं कि ऑटोनॉमस स्टेटस या ऑटोनॉमस बना दिया जाए उन सारे ही सेंटर्स को। अभी एक और इम्पोर्टेंट इशू है, फ्रांस ने अरेस्ट किया है टेलीग्राम के CEO को, पॉवेल डूरोव को अरेस्ट किया है फ्रांस ने। एंड द मेन रीजन वाज पीपल आर सजेस्टिंग इज that Pavel Duro was born in Russia, so that's why European countries are treating the CEO of Telegram this harshly. So this is the last news that we are discussing today. That this is kind of a historic event for Bangladesh that they have defeated Pakistan. They have defeated Pakistan by 10 wickets in Rawalpindi on Sunday. So this is one important news that that we are discussing. Now with this we have completed the news analysis of 26th of August 2024. And if you have any questions, then you can ask those questions in the comment sections. And please, अगर आप लोग को ये एनालिसिस सेशन यूजफुल लगा है तो प्लीज़ वीडियो को ज़रूर लाइक करिएगा एंड सब्सक्राइब टू द सक्सेस मंत्रा डिजिटल चैनल. So with this, we are wrapping up this session. Thank you so much for watching this session. Thank you.